Good evening to all of you. So, as you know, we are here to have a workshop basically on academic legal research and writing. This research and writing obviously forms a integral part of not only your academic curriculum in your law colleges, but also a very substantial part of whatever practice you aim to do post your graduation, whether it's in the corporate field or education field or whatever field you choose. Therefore, having a good command over not only your legal research abilities, but having a pretty good command over how you articulate your legal research depending upon what the outlet is and what the requirement of the situation is a skill that not only law students but every practitioner of law needs to have. In this context, we're going to discuss today some basic things about what you need to have in mind before you start writing any legal a piece whatsoever, be it an article, a blog, or a journal paper, a research paper. And whatever skills you learn today, whatever skills you read about today, will obviously come in handy when you apply these skills in a practical field. For example, you are serving a notice upon a corporation for on behalf of your client, or you're drafting a writ petition, or any sort of thing. Therefore, having all these skills is very relevant and very important for a law student. So the outline for the session is simple. We'll be dividing this into two parts. First, we'll discuss some theoretical aspects, basic theoretical aspects, and then we'll learn about how you apply these theoretical aspects into the practical working when you start to write. So before you decide that you're going to write something or you want to write something, there are four essential things that you need to not necessarily figure out in its entirety, but have a basic rough outline about how you're going to use it. Four basic things that you need to have, not many, is you need to have a topic, you need to have a proposal, you need to have a research methodology, and you need to have an analysis way, or moreover, an analytical methodology. These four define the broad contours of your academic writing. Firstly, starting with the topic, a topic doesn't necessarily mean a title. A topic can even mean narrowing down on an area of law that you are interested in and that you would be writing upon. Now, how do you narrow on an area of law? Primarily, there are two methods. Either you can choose an area of law based on your personal liking. For instance, you are very interested in constitutional law, so automatically your writing will reflect a certain amount of constitutional analysis in it. Secondly, you can choose a topic not only from your area of interest, but also from contemporary happenings. For example, a particular law, particular policy, or a particular arrangement is in place in the country and is currently being debated, say in the parliament or in the Supreme Court. You can start or think about writing on it. Moreover, a topic can also mean deriving a theme from any contemporary issue. For instance, if you read in a newspaper that there is a standoff between the center and state on certain issues regarding distribution of money or distribution of resources for COVID crisis, you can automatically derive a theme upon which you can write. For instance, in this case, the theme would be not a center-state relationship, but mostly a broader theme of federalism. However, after you have decided on a topic, an area of law, or a contemporary happening upon which you would write, that doesn't necessarily mean that you are well equipped to start writing. The second thing that you will need to narrow down inside this topic is your proposal. Now, the proposal can be of many types. Basically, three types of proposal are there. Either you can choose to make a particular claim. For instance, in your paper, in your article, in your blog, whatever you're writing, say you have narrowed down on unconstitutional law, and now you want to make a claim, and the claim being that a particular section or a particular act which is currently being debated in the parliament or which has been passed by the parliament, a particular section or a particular that act itself is not constitutional, or is ultra vires, or is in stark defiance of constitutional freedoms. This forms a claim. You need to have a claim in your paper. Second type of claim that you can have is you cannot make a claim, but you can contest a claim. Contesting a claim would mean, for instance, if the government brings a policy regarding, say, education and says that the objective of this policy would be XYZ, what you can do in your paper is you can contest this claim of the government that no, This stated objective will not be fulfilled is not true, and the means adopted by the government to fulfill this objective is not correct and also in stark contravention of our fundamental freedoms. Thirdly, what you can do is, if you're not making a claim, if you're not contesting a claim, what you can do is you can explore relations between fundamental and competing claims. For instance, if a policy has been applicable in India, say on a morally sensitive issue of surrogacy, there will be many claims which will be dealing with surrogacy laws. There would be an aspect of an ethical consideration, then there would be an aspect of a feminist consideration, and a privacy approach, a human rights approach. There can be a lot of approaches to a particular issue. You can approach the same issue in different styles. What you can do is you can contest claims as in, is the feminist approach towards surrogacy law much better in our context, or the human rights approach? So you can explore connections between two contesting claims also. Moving on to our research methodology. After you've had a topic, after you've narrowed down an area of law, and now you have a proposal to make, as in you know what you're going to say in the paper, you need to be very sure of how you're going to support your claim. You have a claim in mind, but you need to support it. To support this claim, you need to form your research methodology. Research methodology would essentially mean what type of literature you are going to engage with in your paper. As in, say you are going to make a particular claim. So to take that claim home, you can either use judicial precedents, case laws, or you can rely upon academic literature, or in some cases, people even rely on empirical research. For example, if you're writing a case on, say, the condition of prisoners, then you might want to look at an empirical study done by CNLU Delhi. It has done an empirical study on the condition of prisoners. So depending upon your proposal and depending upon what claim you want to make, you need to smartly choose what research methodology you're going to use. Are you going to use judicial precedents? Are you going to use academic literature, empirical data, or maybe a hybrid of everything? Depends upon what you're going to argue. And we are going to highlight this more when we come to the practical aspect of our lecture. Fourthly and lastly, what is required is an analytical methodology. Now, if you go back, while framing your research methodology, the primary objective was figuring out what type of literature you are going to engage with. Case laws, academic literature, empirical, whatever. When you are worrying about your analytical methodology, you need not worry what type of literature you're going to engage with, but your primary questions become how you are going to engage with these particular literature that you have chosen. Supposingly, in your research methodology, you choose 4 academic papers and you have your claim, and you're going to support your claim by 4 academic research papers. In your analytical methodology, what you need to work upon is how you are going to engage with the work of these 4 academic papers. You can adopt many approaches. Say, firstly, what you can do is you can take the previous work that is mentioned in these academic literature and build your arguments upon that. Or maybe what you can do is you can give an entire summation of what literature exists on a particular topic and argue that the existing literature is not sufficiently analyzing a particular lacuna or a particular deficit in law, and by means of your paper or your article you are going to fulfill that. Essentially, you're going to either use previous literature to support your argument, or you're going to refute previous literature to make a radical claim. In both the situations, what you are not going to do is merely summarizing whatever has been said previously in context to your issue. Now, a very important aspect of dealing with these 4 things is not only knowing what you're supposed to do, but also knowing what categorically you are not supposed to do. Say, in the first aspect of researching a topic, a primary mistake that all editors have shared among themselves is, while reviewing papers, the very fundamental aspect of your paper that mostly earns a straight away rejection of your article is that your topic is too broad in nature. For instance, I think yesterday only I reviewed a paper whose title was Cyber Laws in India. Now, a paper titled Cyber Laws in India is too broad. There are too many aspects to deal with. There are too many issues at hand. There are too many controversies in cyber laws in India. You are not narrowing down your topic. You're not narrowing down your area of field that you're going to explore. This is a very fundamental mistake that people do. and which you must at all costs avoid. Having a broad area of law, having a very broad topic, diminishes not only the efficiency of your paper, but also the chances of it getting published anywhere. Because the broader a topic it is, the more you have to discuss in detail, and the more chances you have of going off trail and not focusing on your central argument. Secondly, when you come to say proposal, a major issue with a lot of articles and blogs submitted online is that there is absolutely no central argument in the article. You can go through the entire article, you can read the entire blog as editors, and you would find that right from the first line to the last line, there is absolutely no central argument that has been made, and there is no claim that is being made. In a sense, these sort of papers end up as being mere summation of issues, as in there is a topic, there are some issues, and you merely list down things that other people have said about it. This neither reflects the essential quality of originality nor any contribution from your side from the existing literature. Thirdly, when you come to research methodology, what type of mistakes do people commit? For instance, assume that you're going to write a paper, and the objective of the paper is that you're going to prove that XYZ section of a particular legislation is unconstitutional. Now, to prove that a particular section is unconstitutional, suppose you come to your research methodology and you choose foreign court judgments to rely upon. Now, in your research methodology, what you had to do was you had to choose the literature that you're going to rely upon. And essentially, so you chose the literature that you're going to rely upon. But if you think about it, no matter how strong and how potent the arguments in the foreign court judgments are, if you're going to rely on foreign court judgments to prove that a particular section of Indian legislation is unconstitutional, then by the very scheme of it, your argument becomes inherently flawed, because the claim that you're going to make and the literature that you're going to use and to support the claim is basically having a mismatch between them. You cannot say an article is unconstitutional because a foreign court says so. Maybe if you're doing a comparative constitutional analysis and then you're referring to different provisions of different constitutions, it might make sense. However, if you are directly saying that a particular legislation is unconstitutional in the Indian context, what you need to do essentially is rely upon Indian cases and Indian literature on the aspect. Therefore, having a mismatch of your claim and the research that you're going to use to support your claim is another inherent flaw that is majorly seen in all articles and papers. Lastly, coming to a flaw in analytical methodology, a major problem in this issue is, with this respect, is that people choose a good area of law. People choose a claim, a very strong proposal. They have a strong research methodology. They have laid down what literature they are going to engage with. However, when you come to a paper, the essential part of a paper is the analytical process. In the analytical process, what people tend to do is, instead of working upon the previous literature or instead of refuting previous literature, you end up providing a brief summation of whatever literature exists and merely putting forward your point and masquerading it in some form of an opinion which already exists either in a journal or an article. Therefore, having a lacking originality and not supporting your claim with novel arguments or building upon existing literature, and essentially cramming up any issue and just writing whatever has been previously said is one of the major defects that leads to the rejection of most of the articles on. Now, this basically covers a fairly theoretical aspect of what you're going to write and how you're going to write. However, now we'll see in this part of the webinar that how you're going to apply these things and end up with a paper. Now, in the practical side of it, when you say you sit down now to start writing a paper, there are a lot of things that you need to first ask yourself before you start writing. For instance, if you've sat down to start writing, the first primary four things obviously will have: do you have a topic to write? Do you have a proposal to make? Do you have a research methodology? And do you have an analytical methodology to support it? However, even after you have had it, you are not ready to write. What you need to do is, first you will need to figure out that what you are going to write and where exactly do you want to get your work published. You see, if you're writing and you're not getting it published, then that is Not a very good thing. You must aim to get your work published. That is how you will get recognition. That is how people will read your work. So primary motive of writing is getting published. But this is a very flawed approach as to that you write something and then you decide, oh, where do you want to send it to publish? Instead of this, one must have an approach of figuring out where do you want to submit your piece, where do you want to see it published, and then figuring out how you're going to approach it. For instance, you might choose any topic, and if you sit down and you decide that you're going to publish this in a, say, international journal, in an international human rights journal, then the approach that you're going to take in dealing with the same issue is going to be starkly different compared to a situation when you decide that, okay, this is a piece and I want to get it printed or get it published in an Indian digital media outlet. For example, you want to get published something, you want to get published on a LiveLaw, will have a very different approach compared to something that you want to get published in a, say, National University journal. And compared to both of these, the approach is going to be starkly different when you are going to submit the same piece on the same topic in an international journal. So before you start writing, you need to have a rough idea in your mind that where do you want to see this piece get published. Now, a concerned issue regarding this is, how do you figure out what is a good place of publication? See, with the advent of online digital era, everyone is publishing something and people are having no paucity of outlets for their pieces. Therefore, it is very important to choose outlets that are dignified, that are respectful, and that command a certain respect in the academic culture. You can get your piece published in 1,000 places, but even none of it is relevant enough, if none of it has a structural peer process, a peer reviewed journal or a peer reviewed system or any sort of basically review system, your piece, no matter how good it is, will lack a certain amount of authenticity to it. Therefore, while figuring out where to publish your work, you might want to have 3-4 points in your mind. Firstly, say you've decided a particular outlet. Now, how do you know whether it is good or not? Primarily, a first thing that you should look for is whether it has a good institutional affiliation. For example, you're looking for a criminal law blog of, say, NLU Jodhpur. Now you know that it has an institutional affiliation with NLU Jodhpur, so obviously it has a review system, a peer review system, and it has a good institutional backing to it, so it automatically becomes a good journal. However, many of the journals are there, many of the articles and many of the blogs are there which do not have institutional backing but are still very good and still very relevant. How do you figure that out? When you've decided that you want to publish in a particular journal, what you need to do is have a look at its editors, have a look at its board of editors. Everything is mentioned on the website. Do not send your piece to a particular journal which is not having reputed editors, or which is not having any system to check and review, and which is just publishing your piece randomly with no review and with no feedback. So what you can do is you can check their website, see who the editors are, see are they qualified enough, see are they good enough, and most of the cases there are advisory editors on board, and see most of the advisory editors are working professionals, reputed working professionals. So if you see that the board of editors or the advisory professor or the advisory board has reputed people, then automatically that becomes a very good outlet for your piece. A golden rule in mind: any journal, any blog, any outlet that, say, asks you to pay some money in exchange of publication is not worthy. Even if you get it published there, even if you have 100 publications like that, it won't be considered worthy enough. So please don't pay for the publication. That is a predatory practice. And lastly, do have a check at their previous published work. What sort of literature have they published? What sort of articles have they published? And if you think that there are good academic pieces available on their website, available on their journal, available on their outlet, then you can think about publishing your piece there. Now let's move forward. So what you have now is, you say you have a topic, you have a proposal, and you have everything, and now you have chosen a journal, and now you want to start writing about it. As I previously said, the same issue, a same contention can be dealt with in very different ways depending upon where you want to have it published. For example, now I'll take up 5, take 7 types of articles and types of blog and types of journal papers that you can attempt to write. Different types of papers. For instance, a very basic form of academic literature, whether it's blogs or articles that you're going to find online and in print, is when the Supreme Court of India or the High Court of India refers a particular matter to a larger bench. Whenever the court or law refers a matter to a larger bench, you have a very decent opportunity to write a robust and a sound academic paper out of it. How do you go about doing it? That's a very grave area of concern now. So say Supreme Court of India has referred a issue to a larger bench and you have frowned upon it and now you want to write something about it. What is the one thing that you should not do while writing such an article? It's the most basic form of article that you can write. I'm not talking about any advanced article right now. It is the most basic form of article that they were, and obviously when a reference has been made to a larger bench, that essentially means that on the same issue of law, there were existing two competing judgments, and the Supreme Court has now referred the issue to a larger bench so as to erase the discrepancy between the two competing judgments that existed. Now, the most primary form of writing would be that you define the issue, that XYZ is a particular issue that is being debated in the Supreme Court right now. And there are two competing judgments, which are obviously of opposite in nature, and that is why the reference has been made. And in your piece, through your piece, you're going to take a stand as to say if two judgments are there, you're going to say that the first judgment, which lays down the position of law with respect to a particular issue which has been referred, is the correct one. And through your paper, you are going to make and lay down an analysis of what the Supreme Court should do through its reference while deciding the particular issue. This is one of the most basic forms of academic writing. However, a very big mistake that is done in this is when you are dealing with two judgments which are referring to the same issue of law, what essentially people tend to do is, although they are writing a introspective and a novel article, what they end up doing is basically they end up summarizing both the judgments in chronological manner and just end up saying that, okay, this was the first judgment, this dealt with XYZ issues, and this is the second judgment, this dealt with ABC issues, and I am eventually siding with the first judgment and I want the Supreme Court to say that this is the correct judgment. This is the structure of how people end up writing. What you can do to avoid writing this is, instead of analyzing the issues that exist in the judgments, what you need to do is analyze the judgments through the lens of issues. For example, say you have two competing judgments on judicial immunity. A first judgment says that a judge can be punished for whatever he does through in the course of his exercising his powers as judicial functions, and the second judgment says that a judge cannot be punished while exercising his functions as a judicial authority. It's a made up case, but still, what people tend to do is they just summarize the first judgment and the second judgment. But what you need to do to make it a publishable quality is you need to discuss the judgments in light of the broader issue that exists. So in this situation, the broader issue that exists is of judicial immunity, the power of judicial immunity granted to the judges. So you now analyze the judgments through the concepts that is available. So what you end up saying is, okay, in both these judgments, there are three issues that come out. And now you're going to list down those three issues, and under each of the issue, you're going to see and contrast how both the judgments on the issue have dealt with the same issue. So instead of merely summarizing the issues in the judgment, you are now analyzing the judgment from the lens of the issues. It is only when you offer a novel perspective like this that your paper becomes relevant, it becomes contemporary, and it becomes a publishable quality. Because see, if an issue is burning and if issue is contemporary, everyone is going to write about it. Unless and until you make your work different, and unless and until you offer a novel perspective, no editor is going to approve your piece. However, secondly, let's come to a different type of article. This was merely a reference article that when Supreme Court has referred a matter. There are other instances also when, say, the Supreme Court of India has admitted a plea for anything. For instance, the Supreme Court admits a plea to deal with the constitutional bias of a particular section. Now, this is different from the first one. In the first case, the court was dealing with a few issues. The hearing had happened, and then it referred the matter to a larger bench. In this case, what the court has basically done, it has just admitted a plea to decide the constitutionality of a particular section. Now, suppose you want to write on this, and you want to write on this on international blog, say an Oxford Human Rights blog or a London School of Economics blog. How your approach is going to differ now. Firstly, the moment you start writing for an international publication, the moment you sit down to write for an international audience per se, what you need to have in mind is they are not equipped with an understanding of your governing structure. So whenever you start writing for international publication, the first thing that you need to do is essentially lay down the governing structure of whatever issue you are arguing in the first paragraph itself, as in what are the relevant authorities, how is the particular issue controlled. Say you might very well be acquainted with an Article 21 challenge, but a person in a foreign jurisdiction is not aware of what Article 21 is. So no matter how big and important it seems, please, when writing for international audience, lay down the basic things in your article in the very first paragraph itself as to what Article 21 entails, what is its importance, how it has been dealt with, and what you are going to argue. Briefing an international audience with respect to every basic aspect of law that you somehow ignore while writing for an Indian context because you assume a basic understanding of, say, an Article 14 or Article 21 is a very big mistake. You need to acquaint the international audience with every basic necessity that is required to understand your piece. Now, when you say that a particular claim has been made in the Supreme Court and say a particular section of the Special Marriage Act is challenged. Now, what you need to write in your article or what you need to think on the lines of saying that, okay, the Supreme Court has admitted the challenge. What I am going to argue in my piece is that this challenge must be decided, whatever your opinion is, in favor of the judgment or in favor of the legislature, or this section must be struck down. Whatever side you choose, what you must keep in mind is that what you are essentially dealing with is the constitutionality of a legislation. While dealing with specific legislations and their constitutionalities, a big mistake that is essentially committed is in choosing your research methodology. Say if you're targeting a section of Special Marriages Act, whatever arguments you make, whether it be for or against, they must have a particular rooting in legislations and case laws, because the court is not going to eventually decide upon the constitutionality based on a social literature aspect or a socio-economic aspect of it. Social writing is very different compared to academic writing. When you are deciding constitutionalities of particular legislations, your research methodology needs to stick down to legislation, interpretation of legislations, and previous judicial pronouncements. However, if you happen to critique not a legislation, not the constitutionality of an act, but a policy that has been implemented by the government in the same setting, in the same nature for international audience or a national audience, what you can end up doing is you can say that I'm going to analyze a particular policy that has been brought by the government. For instance, you might want to write a paper on the particular, say, redevelopment policy of Lakshadweep. Now, when you're writing or critiquing a public policy issue, this can have a social aspect in your writing. In here, you can allude to social studies, you can allude to theories, you can allude to anything that you want, because you're not discussing the constitutionality of an act. Now, moving forward from judgments and the references, there is another form of writing that you can engage with and that you must try at some point of time in your law school, is a theoretical understanding of a particular issue. For instance, take the issue of Sabrimala. It's a well understood issue. You must have heard about it. The Sabrimala temple entry issue. When the issue happened, everything from the judgment to the issues to theoretical aspects to human rights aspects to feminist aspects was written down. If you want to end up writing on such a widely written issue, what you need to do is you need to have a novel perspective on it. And how do you get the novel perspective is the major question. What you need to do is you need to figure out a theme in any particular controversy. Say in the controversy of Sabrimala temple entry, the theme was women's right, a broad theme, right of women. Once you have figured out a theme, what you need to do is you need to have a particular philosopher or a particular legal theorist. For instance, you can choose Plato. If you choose Plato, now what you have is you have a theme of women's rights and you have a theoretical philosopher, you have Plato. What you can do is you can look for the theme of women's right in Plato's work and then contrast whatever he has done in respect to women's right with what the courts are not doing. Maybe you'll find up something which the courts may allude to while deciding, or maybe you can find something which the courts could have done or should have done. Essentially, what you're going to do is you're going to take up an issue and analyze the same issue from a theoretical perspective of any legal theorist or a philosopher. What is that? What this does is instead of providing the readers with a monotonous, say, analysis of what everyone has said, what the judges have done, what is equal rights, Article 14, Article 21, the same things keeping repeated. So when you choose a theoretical stand like this, it offers a very fresh perspective to a particular issue that is currently being debated across the country from the perspective of a theorist or a philosopher, which people might not have studied. So maybe after reading your article, the people will be equipped with how Plato would have handled the issue. Or if you are dealing with a more theoretical aspect and a more legal aspect, what you can do is you can take up a recent public policy issue and see how a legal theorist, say John Rawls, how John Rawls would have reacted to it, or how in the work of John Rawls you can find some theoretical grounding for what the government currently is doing or what the courts have done. Say a particular interpretation of a section in a court, you might analyze that particular interpretation, a recent judgment from the lens of, say, a Dworkin or a HLA Hart or anyone, right? Basically, what you need to do is you need to take up an issue, you need to locate a fundamental theme in that issue, and you need to work that theme under the work of any established legal theorist, any established philosopher, thereby providing a very novel perspective to an existing issue at hand. Now, again, I just wanted to go back to that international publication thing. Whenever you are dealing with any international publication, it was, as I told you, it was very important to lay down the governing structure. However, it is also very important to not just lay down what the governing structure is, but explain everything that you are writing with respect to the authority that is concerned. For example, if you are discussing about, say, the new transgender rules, right? The 2009 transgender rules that was sort of notified by the executive, and you are writing about that. There are a mention of a lot of authorities. For example, the central ministry, the district magistrate, the SSP, everything is mentioned in there, and you need to discuss everything while writing for international publication. What you need to do is don't make your article devoid of any context. Explain it to the reader, especially when you're writing an international audience, as to what the position of a district magistrate is, or how this particular act was explained, or how this particular act was notified by a ministry. When does this, which department does this ministry come in? How is it made, or what authority does it have, and how can it be challenged if it has been notified? What are the grounds of challenge, how it is usually challenged, and what you are going to argue? Because unless you provide a context in whatever you are writing, and especially for international audience, the paper is very devoid and very blank of any source in it. Now, another form of writing that you can do is you can write book chapters. So say you've come across call for chapters. One thing more, you have all the legal websites at your disposal, and they periodically list down how you need to, how the blogs or whatever chapter or whatever journals are calling for journals and calling for blogs. and you must surely visit them once in a while, once in every week, or howsoever you want to do, to look for publishing opportunities, as in where you can publish. Unless you have prepared your list or you know where you want to publish, you people are generally not aware of, okay, I want to write and I can write something, but where do I publish it? So you must keep referring to all your legal websites to keep a track of what you where you can publish. Then, yeah. So suppose a lot of publishers, what they do is they list down a particular theme, and they say that we are going to publish a book on this theme, and for that book we are calling chapters. So essentially, you can end up writing a chapter in a particular book which deals with a particular theme. This is also a very good outlet for publication of your work. Now, when you're writing an article or when you're writing a blog, the writing is slightly different as compared to when you're going to write, say, a book chapter. While writing a book chapter, the primary thing that must guide your writing, the primary thing that you must pay attention to each and every time, is the theme of the book itself. Every book that calls for chapters has a particular theme around which it wants to publish, and that theme has particular subsets and internal subsets as to what categories of article you're going to publish. Please do not start writing, please do not attempt to write unless and until you are well aware of the contours of the writing, as to what the expectation of the editors are, as to what the expectations of the book is, what the expectation of the journal is. And in this respect, not only in book chapters, but in everything that you publish, you must have an idea of what is being expected. How you can find this? It is very simple indeed. If you're going for a book chapter, while the chapter is being called, usually and in 99% cases, the editors list down the requirements of what chapters they want, what are the sub themes that they want. Say you're writing a chapter on intellectual, say the book is dealing with intellectual property rights, and there are 4 themes in it, and one of the theme is climate related intellectual property rights, and a sub theme of climate related intellectual property rights is, for example, compulsory licensing in cases of pandemics. So what you see is whatever topic you choose can be fitted amongst one of the subsets on the themes that has been laid down. Unless you are sure as to what category you are going to write for, you must not start writing, because you might end up writing a very beautiful paper, a very beautiful article. But if it does not fit the requirement of the editors, it will not be published. With respect to blogs and articles, what you can do is, before you start writing, say you have decided that you're going to write for say London School of Economics. Okay, you might write a very good paper, and you might make absolute sense, and it has been legally very sound. But if you are not complying with their requirements, with their style, then it is not going to be published. You will have explicit and excruciating rounds of editing going on. What you need to do is, before you start writing, refer to where you want to write for. Go to their website and check the requirements. Every good journal, every good blog has a note for their authors, a note for prospective authors, where they lay down exactly what the requirements are. And the requirements can deal with something as basic as the area of law, that, okay, this is a commercial blog. So obviously, you're not going to submit an environment law piece to a commercial blog. Two small details as to what is the word count, what is the type of literature that we're expecting, what is the style of footnotes that we expect. You might have a very beautiful paper, but you say you have used Harvard style of footnote and the required blue book citation, it will not work. Or they required, say, Indian Law Institute citation, it will not work. You need to have a very strong idea as to what this type of citation is required, what is the type of literature that they require, what is their word limit, what is their area of law. And unless you understand all of this, started writing, if you started writing without understanding all of these things, it is mostly going to be a waste, because you're going to end up randomly sending your piece to different outlets which have not been designed for your piece, and they're going to reject it prima facie without even a proper review, because you do not meet the criteria. Now, another form of ad writing that you can attempt to make is, what if you have a particular issue to write upon, a particular thematic issue to write upon, but it is not in any contemporary discussion that is going on. For example, you might have a very good take on the NALSA versus Union of India judgment of transgender rights. Okay, you might have a very novel take on it. However, the judgment is, I think, 10, 12 years old. Why would you want to write on something that is so old now? Why would someone read it? Or why would someone end up, say, clicking on it to read, whatever? If you attempt to write on something that is so obsolete, and it might be recent 10, 12 years or 50 years, whatever, you need to make it connected with any recent happening. For instance, what you might end up doing is you might say that, okay, this piece, this article is going to revisit the discussion on transgender rights in the context of NALSA versus Union of India with respect to a particular current happening. For instance, new transgender rules have come in. In context of that, you might want to discuss the original act or the original judgment, or a particular public policy has been brought in, or a particular incident has happened where a grave violation of transgender right has happened. Only when you're able to connect your piece of work with some contemporary relevant happening does it actually appeal not only the readers but also the editors. Unless your piece has a contemporary appeal, the expedited review that most of you urge for and most of you require and expect is not very prominent to give. If you want your piece to have an expedited review and getting it published as soon as you submit it, your article must have some contemporary aspect to it. Now, these were all journals and articles and international publications and whatnot. But there are different other types of writing that you might want to engage with. For example, digital media news writing. For example, you want to submit a column on LiveLaw or a bar and bench, or for that matter, a newspaper, say Times of India or Deccan Herald or the Hindu, whatever you want to submit to. The style that you want to write for in a proper academic journal or a proper academic blog is very different from what you're going to write for, say, a newspaper. First, let's discuss a newspaper. So you want to write a online blog or an online article for the Hindu or the Deccan Herald or whatever you want to write for. The moment you write in a popular media, the moment you write for a newspaper or say the Wire or the Scroll or the Quint, whatever you want to write for, you must have this particular thing in mind that the reader, the audience, is not a well-seasoned lawyer. They are not going to understand references to sophisticated arguments and to sophisticated acts and legislations. So the moment you tone down to social writing, to popular media writing, your writing must be devoid of any legal jargon, of any complicated arguments that seem very monotonous to you in an academic journal, because you need to tailor down your pieces for the readers, and an average reader of an average newspaper might not be very fluent with, say, 3 or 4 doctrines that you want to discuss. If you are going to discuss doctrines for a newspaper, that piece is not going to be published, and even if it does, the readers won't understand anything. So if you're writing for, say, a newspaper, you need to narrow down, you need to short down your work, you need to have, say, a more ease down approach to it. An ease down approach not necessarily means that you are not going to discuss what the legal aspects are. Say you are discussing something with rights of with reference to Article 21, and you are not going to not cite cases, and you're not going to not cite the previous jurisprudence in that manner. However, you're not going to cite it with a particular academic tone, but what you're going to do is you're going to bring in some social aspect in your writing. By social aspect, I do not mean that you're going to start discussing the goods and bads and everything of it, but tone it down for the average reader. Having your reader in mind while writing is the utmost of utmost importance. Secondly, say you're writing for a column for a legal website, a renowned legal website, the LiveLaw, Bar and Bench, whatever you want to write for. Attempting to write such an article is again very different from a proper academic journal. Say you want to submit a piece on Indian Law Institute Journal and a piece on LiveLaw on the same issue, on a very same issue, both the pieces are going to be starkly different. While writing for legal websites like LiveWire and Bench and everything, it is very important that first of all, as you must know at this stage, they do not accept citations. They do not want you to have deep academic citations. You're going to use hyperlinks for most of your academic work. Proper cross-referencing and proper referencing of why you are writing it is very important. Do not make, in any circumstance, do not make your reader look for your central argument in your paper or in your article. Make sure that whatever you are going to write or whatever your central argument is available to the reader in the very first paragraph or in the very start. The reader must know what he should expect or he or she should expect from the paper and what you're going to argue. Do not end up giving a detailed analysis of jurisprudence and a detailed list down of cases and everything without even informing the reader as to what you are going to argue. Say if you want to state that a particular judgment of the court is wrong, a recent judgment of the Supreme Court is wrong, do not just start citing authorities as to what this judgment says, what the judgment says, and what the court has done. Make sure that you explain to your reader that, okay, the Supreme Court has given recently this judgment. The judgment deals with the issue of XYZ. And I, through my paper, I'm going to explain that how this judgment has misinterpreted a particular debate and how it is wrong. And to explain and to take home my point, I am going to rely on XYZ things. Please have a broad outline of your work in mind. And unless you have figured out the broad contours of your writing and the broad contours of what you're going to eventually conclude with, starting a paper in that state of non decided situation obviously tends to haphazard pieces that do not have any coherence. Because make sure, even if you write a very beautiful piece and keeping in mind all the tenets and you have the claim and proposal and research and analysis and whatever, if the piece is not coherent, if each paragraph is not naturally flowing from its previous paragraph, if the flow in the paper is not there, if the coherence is not there, if a general structure is not there, it becomes very difficult for editors to approve such pieces, and it is very difficult to get published without having a certain coherence in mind. Coherence you can eventually get by reading and obviously by continuous attempts at writing, but you must at all times attempt to maintain a certain amount of flow in your paper. Every paragraph in your paper, every paragraph in your article must naturally flow from your previous paragraph, especially in digital media writing where the interest span and is very limited for readers. You don't want your readers to look for something in your paper. Whatever importance there is, you need to strike it down right in the very beginning of your paper. Now, these things also help you, say this aspect of striking down in the very beginning also helps you while you're writing some professional stuff. For example, you want to for your client, you want to write a representation, say to the defense minister, right? Some of his property has been taken up by military land and you want to write a representation to the defense minister. If you are writing a representation to some authority on behalf of your client, obviously it means you are pleading for some relief. You want the interference of the higher authorities in a manner. If a representation comes to them and they're reading it and they're not able to find as to what is it that you want and what relief can we provide, why would anyone bother reading such a representation? Therefore, while you're writing, say, professional representations or professional articles, be very sure of this point that whatever you're going to write, whatever it is that you want to argue, and you must have something to argue, that is mentioned at the very start of the paper, at the very beginning of the paper, so that the readers do not have to look for what it is that you want to argue and how is it that you are going to argue. Same thing applies to, say, you are writing a writ petition of some sort. Unless you are very clear as to what remedy you want, unless you are very clear as to what directions you want the court to issue to you, you cannot write a writ petition. You might have a very bound, very thick writ petition of 500 pages, but if it is not clear as to why the court should interfere, as to what remedy the courts are being asked of, the court is not going to read it. The court is not going to entertain it. It is going to be thrown off no matter how legitimate it is. Therefore, whether it is professional writing, notices, writ petitions, commercial documents, agreements, whatever, or academic writing, you need to be very sure of mentioning what you require at the very start and very explicitly. There are a lot of papers, there are a lot of blogs that come in, which you can read through the entire blog and you will not find a single central argument. Therefore, making sure that you list down your central argument is very important. Now, also a slight note on how you're going to start writing and how you're going to have your first draft prepared. Now, firstly, let's be very sure of this. Your first draft is never your final draft. You write a first draft of anything just so as to have a particular structure in mind, and then you're going to edit it. When you start writing, when you think about writing, firstly, as previously mentioned, have a particular outline in your mind, an outline as to what the topic should be, what the area of law that I'm going to engage with is, what the research methodology would be, what literature I'm going to use, because you will have to use something. You cannot write a paper or an article out of thin air. You will have to refer to some sort of previous existing material. So make sure you have what you want to refer to, and then make sure you have an outline of how you're going to refer to it, whether you're going to use it as a support, whether you're going to critique it, or whether you're going to build upon it. Then when you have these things in mind, then you can go on to the next stage of referring of figuring out where you want to see your work published. There are blogs of, say, every national law institute, almost every college, which deal with particular areas of law. So if you want to write a piece on environment law, you must look for good journals of good reputed colleges which deal with environment law, or even independent journals and independent outlets which deal with environment law as an area of concern. People tend to make this mistake of submitting one area of law piece to a journal that does not deal with that area of law. You must avoid it. It's a very basic mistake. Second, thirdly, when you have figured out where you want to see get it published, you must look as to what the expectations of that journal are, as to what they want, how they want it, what is the line, what is the word limit, what is the type of referencing that they require. And fourthly, then you need to figure out that how the central claim, whatever proposal you had in mind, is going to be rooted in that paper and how you're going to fix it. As with the proposal in mind, as with the central claim, I told you there are different types of articles that you can attempt to write. Firstly, as I told you, the referencing. Whenever the Supreme Court grants a reference, whenever Supreme Court refers a matter to a higher bench, you can write a paper, you can write an article out of it, depending upon what side you're going to choose. You can say that, okay, there are two competing judgments, and I'm going to side with this particular judgment for this, and I'm going to prove that how this judgment must be upheld. Secondly, if the Supreme Court has admitted a plea to something, what you can say is that, okay, the Supreme Court has accepted a challenge to XYZ section of the act, of this act, and I, through my paper, attempt to make the point that this act is indeed unconstitutional, and what are the instances, what are the legal points that the Supreme Court must look forward to, the Supreme Court must analyze while striking down this law. This is what you're going to provide to your readers, because the reader knows that, okay, plea has been admitted in the Supreme Court to challenge this, but they don't know how this is going to be adjudicated. So this is exactly the thing that you're going to provide. One thing more that you can do while writing for legal articles is you can recharacterize a debate. How this works is, for instance, there is an issue of, say, advocates are not allowed to advertise. Okay, it's a very basic issue. Everyone knows this. Bar Council of India rules prohibit advocates from advertising. Now, if you know this piece, the Bar Council of India has, the Supreme Court of India has recently accepted a plea to look into this issue on when an advocate appealed in the Supreme Court as to that in wake of COVID-19, the advocates must be allowed to advertise. Now, if you read about this, the entire debate is going to be dependent upon how not allowing the right of advertisement to advocates infringes your Article 19 rights. Okay, basic freedom of speech, and you are infringing upon the freedom of speech. Now, what you can do is you can recharacterize this debate. For instance, I wrote this piece for Bar and Bench when I was discussing this very issue of how the advocate's right to advertise has been historically categorized as an issue of infringement of advocate rights. What you can say is that, okay, although historically the entire issue has been characterized as a matter of infringement of advocates' right, this is in fact not an infringement of an advocate's right, but more an infringement of the right of the people to know the professional antecedents of their advocates. It is a violation of Article 19(1) rights, not of the advocate, but of the person, but of the litigants involved. How you're going to prove this? You might have to choose with a radical proposal, you might have to choose a radical outcome. For instance, you might want to form a connection between the previous judgment of the Supreme Court, wherein it stated that the people of this country have a right to know about the professional antecedents of their elected representatives, the MLAs and the MPs. People have the right to know about them. What you can say is that, okay, the reason of the Supreme Court to grant this right to the people to know about their elected representatives was because the elected representatives perform a public function. Now, if you can say that advocates also perform a public function, you can basically extend that right or that protection to the people, even in the situation of advocates. And what will it do? It will eliminate a lot of issues. For example, you must have heard of the recent 5G application of Jui Chawla and how it was struck out of the court, and how the court said that this is a capital case of how a suit must not be drafted. What if the issue was legitimate? What if the issue was pertinent to discuss, and the lawyer makes a mistake in drafting, the lawyer makes such heavy mistakes in drafting, and the client has to pay for it? Is it not a violation of the client's right to know the professional antecedents and then choose how he would have chosen? Supposing if she had gone with a particular different advocate who might have summed up and who might have drafted the plea in a particular manner, that may have been admitted, who knows? But what you need to look forward to is that you are recharacterizing a debate. You are moving away from the dominant narrative of how not allowing advocates to advertise hampers their freedom of expression and speech, to the narrative that not allowing advocates freedom of right is hampering the client's right to freedom of speech, the client's right to know. Therefore, you do not essentially sum up whatever has been said, but you provide the readers with a novel perspective. It's just an example that I'm giving to you, so as to know, so that you know that you can often recharacterize debates, and that is also a very good piece. That is also a very good attempt at academic writing, where you grant an entirely novel perspective to a particular issue. Now, lastly, I would, yeah, just want to list down 2 and 3 basic mistakes that everyone has done, that everyone does, and that you must avoid at all costs, no matter what form of research or writing you are undertaking, whether it is an academic journal, whether it is articles, or whether it is blogs, or whatever you're writing. After you have written, and preferably before you have written, you must ask this question, and you must ask this question every time you write, that are you performing, or are you providing any particular claim in your paper, any particular argument in your paper? Can your paper, no matter how big it is, even if it's 10,000 words, can your paper be reduced to 1 or 2 lines? 1 or 2 lines, meaning by that you can say that, okay, this is my paper, it is 10,000 words long. However, what it is doing is, it is saying that a particular act of the government is having a non-intended consequence. Whatever policy was intended for, this policy is having an effect that was not intended for. This is a basic statement. You must have a basic statement of your paper. See, your entire paper, no matter how long it is, would just be an exercise in explaining and justifying this particular statement. If you're writing a blog, you might justify it in 1,000 words. If you're writing a paper, you might justify it in 10,000 words. However, you must have something to justify, and that something to justify is essentially your proposal, your claim. For instance, you have written a 20,000 word piece of entire thesis or whatever, but you do not have a central argument in it. If someone asks you, okay, what is your paper talking about? You cannot explain them. You'll say, oh, it's so big, I can't explain whatever, it has so many sections and all. Nothing. It's wrong. You must have one claim. Say the claim of your 20,000 word paper is that say particular rules that have been notified by the government under a particular act is unconstitutional, or say is inconsistent with the act. There are rules that are formed under the act, and if the rules are inconsistent with the act, it is bound to be struck down. This might be your basic point. This might be your basic proposal, that okay, I say that the rules are unconstitutional or inconsistent with the act. Now, your entire article, your entire proposal is an exercise of justifying your claim. And if you're writing and you figure out that, okay, I have a claim and I need to justify it, this only then it becomes a proper exercise in academic writing. If you do not have a claim, if you have written everything and if you've written everything down and you cannot reduce it down to one particular question as to, okay, this is what the paper is arguing, this is what I intend to say, this is what I put in, this is what I'm putting forward, this is what I am adding to the additional literature, your writing is flawed. It has somewhere gone wrong because you must have a proper point. Secondly, a lot of issues exist in this country and a lot of issues have been written upon, and new, especially popular issues have been heavily written. So no matter what issue you choose, people have written on it. People have written on various aspects of it. Like I mentioned the example of surrogacy, for example, people have written on the ethical aspects of surrogacy. People have written on the contractual aspects of surrogacy. People have written on the moral aspects of surrogacy. People have written on the human rights aspect of surrogacy. People have written on the rights-based approach to surrogacy, on the women's right to be
So, I think you have been muted by mistake.
I'm audible.
Yeah, you're audible, sir.
So I was saying that the same issue can be discussed from various lights. Now, if you start writing a paper that is too broad, that is not specified, what you will end up doing is you will end up touching some aspect of human rights issues, some aspect of feminist issues, some aspect of rights-based issues, some aspect of, say, a feminist issue of anything. And what you'll end up doing is you will end up accumulating a lot of stuff in your paper without a clear demarcation of what it is that you're going to argue. So whenever you're going to start writing, and this is the final and the most important thing that someone can issue, please have a structure in mind. Please have a demarcation in mind and please narrow down your topic. If you want to write about surrogacy, narrow down the topic. Okay, surrogacy, I want to write about surrogacy, but I will address a very particular issue in surrogacy as to the right of the women to do it. Or say, I will not deal with the act, I will not deal with the rules, I will not deal with foreign judgments, I will not deal with comparative situations, but what I'm going to deal with is purely the ethical aspect of surrogacy, whether it is morally right or wrong. When you reduce your area of law, when you reduce your scope of literature, when you reduce your area of engagement, the paper is much more refined. The article is much more refined because it is not only directed towards a particular claim, not only it is directed towards justifying a particular claim, but it deals more exhaustively when you are dealing with a narrow issue. When you are dealing with 5-7 issues at hand and you have the limitation of 2000 3000 words, you are not going to exhaustively deal with any literature at hand. You're going to make some points about human rights, some points about the act being wrong, some points about, say, UDHR, some points about international justice and all, but you're not going to exhaustively deal with any particular issue. Therefore, it is more relevant, more pertinent that whenever you start writing, you have an outlet in mind, you have a structure in mind, and then narrow down your structure, narrow down your area of law, narrow down your choices. And it is only then when you couple this narrowing down of your area of law with a proper, strong central argument, a strong central proposal, and back it up with good research methodology and good analytical methodology, that you can turn up a very polished, sophisticated academic piece. Okay, so I think that's all from my side now. You can take up the questions that you have. I think the moderator can take them up so I can answer them.
Sure, sir. Uh, we have so far only two questions.
Okay.
The first question is that what should be the format? I think this question is in a way incomplete. And
See, I'll tell you the format thing. As I told you, the format of whatever you're going to write will depend upon what form of piece you're going to write. If you are writing a research paper, the format is different. If you're writing for a blog, the format is different. If you're writing for international publications, the format is different. So instead of worrying about what the format should be, you should worry about where do you want to see it published, where do you want to get it published. And when you have narrowed down on that topic, please look at their previous publications, at how they have published, what pieces they have previously approved. And when you go through that, you can have a broad understanding of, okay, this is the proper structure that they are approving. And then you can build upon your paper and build upon your argument depending on that structure. There is no universal format. You can write anything in any manner. It depends upon where you want to get it published or how you want to get it done. Okay.
Indeed, sir.
Yeah.
So the next question is that how should one choose a specific title for a piece of writing? And is it necessary that the title must be eye-catchy?
No, it is not necessary that the title must be eye-catching. Again, it will depend. See, your title is probably the last thing that you figure out. Okay. If you have a very good title in mind before you started writing, you're very lucky. But usually the titles tend to change as you approach the paper, because you figure out new literature, you figure out new stuff. What basically you can do is, do not make your title unnecessarily eye-catchy. Do not make it very novel or anything. Do not try to catch attention to it. You're not an Instagram influencer, you're an academic writer. But what you need to do is make sure that your title reflects the central point of the paper, that whosoever reads the title gets a basic idea of, okay, this is what he's going to argue, or this is what the piece is going to contain. And if I am interested in reading that, I will read. Do not make a very ambiguous title or a very vague title as to which does not tell the audience, which does not tell the reader as to what is it that you are going to speak about. Say if your title is, as I previously said, cyber laws in India, or if what you're going to talk about cyber laws in India, please mention it. Say you want to talk about a particular section, say you want to talk about section 69, or you want to talk about freedom of expression with respect to cyber laws, or anything with respect to cyber laws, whatever. Make sure that your title reflects your central argument, so that the author, the reader, beg your pardon, knows what they can expect from the piece.
Okay, so the next question is, how can someone find literature gaps or gaps in literature? For the person says that everything I read seems all right. I don't know how to produce something novel. So, what all should I footnote, and how do I do that?
Okay. See, I'll tell you a small example. Suppose you are dealing with an issue of judicial immunity. Okay, judicial immunity is when the judges are granted immunity from prosecution with respect to anything that they exercise, that they do in the judicial aspect. When you start discussing, when you start searching upon a topic, and you can search case law, the literature, whatever, the same logic applies. You must first figure out what are the founding or the fundamental aspects of this literature. As in, if you're dealing with judicial immunity, you can have, there are 3 to 4 cases, the KK Dhavans and the Rajivs and everything, which lay down the law on the matter. There are 2 types of case laws. There are 2 types of academic literature. One is which essentially lays down the entire parameter, that, okay, this is what the law entails and this is what we are going to interpret it. For instance, say in an academic literature, you are writing something on environment law, and say Garrett Hardin's piece on, I'm forgetting the name, the tragedy of the commons. Garrett Hardin's piece on the tragedy of the commons. That is a primary source of literature. In judicial immunity cases, KK Dhawan's case, suppose, is PC Joshi KK Dhawan's case, is the primary law that deals with the issue, that lists down the issue. A different type of case law is which applies whatever has been said by the courts in the fundamental aspects, in the fundamental case laws. So there are 2 case laws depending upon the same issue. One which lays down the fundamental groundings, and second which applies those cases in particular fact patterns. You are not going to find gaps or discrepancies in the fundamental aspects of it, because whatever has been said has been accepted, and if you are going to challenge that, you need a very strong basis. Easily what you can do is, you can say that, okay, these were the foundational aspects, these were the fundamental aspects, and the courts have used them in XYZ cases, and how the courts have interpreted the fundamental aspects. the foundational laydowns is mistaken or is wrong. Secondly, if you come to academic piece of it, you will have to read a lot. If you have chosen an issue and you want to find a gap in the literature, you will have to cover exhaustively the entire issue. And this is precisely why I say that you need to limit it down. You need to narrow down your research paper, because if you have a very broad topic, you will never be able to write because your research will never end. You're going to increasingly read on new research papers, new articles, and new everything that has been written. And unless you narrow it down, you narrow your research down, you narrow your topic down, you will have a vast array of research papers to go through. And in that situation, you are never going to find a gap of anything. Narrow down your topic, be very specific with your topic, and it is only when you have narrowed down your topic that you are going to come up with some judicial aspects and some research academic aspects that, okay, there are 7 papers with that deal with my subject and there are 10 case laws that deal with my subject. Once you have done a cursory reading of it, then you can start applying it. It is only when you apply the laws and apply the fundamental aspects to any novel situation that you're going to come up with something. For instance, you have the Keshav Nanda Bharti, you have everything that is written under the sun in the Keshav Nanda Bharti. You're not going to find something new in the Keshav Nanda Bharti, but what you're going to do is you're going to use the tenets of Keshav Nanda Bharti in upcoming controversies. Whatever new controversy has happened, say a controversy with regard to the distribution of money from GST Council, that's on the cards right now. What you can do is, the Keshav Nanda Bharti did not discuss a GST Council issue, right? GST Council was not there at that time. But the tenets are mentioned. What you can do is you can lift the tenets from a fundamental foundational case and apply those tenets to new controversies. When you apply those previous existing tenets to new controversies, then see that how the foundational aspects of it come to light when you analyze the issue in light of previous existing literature. That is when you come up with novel aspects. That is when you come up with new aspects. And as I previously said, while coming to new aspects, what you can do is, say, the Sabrimala example. When the entire discussion has been limited to judicial pronouncements and equality and rights of it, what you can do is you can choose a theoretical framework. You can choose a philosopher, or Plato, or Dawkins, or H.L. Hart, or whomsoever you prefer, and analyze the controversy from their perspective. This is something novel. This is a gap, because women's right might have been analyzed from the perspective of feminist authors and equal opportunity writers, but it might not have been, beg your pardon, analyzed from the perspective of the ancient Greek philosophers. So that is when you come up with new stuff. That is when you come up with novel perspectives. You'll have to read a lot to do that, though.
Indeed, sir. That is a very good explanation of and good answer to the question. That since we are running a little short on time, almost all the questions have been answered by you by way of answers to some questions or throughout the course of this session. There is one person, Miss Swasti. She has a question and she would like to unmute and ask it. So
Sure.
I think her question could be the last.
Hello, am I audible?
Yes, you're audible.
Thank you so much for giving me the opportunity. So, sir, thank you so much, firstly, for this insightful session. Sir, my question is, so, sir, in my initial years of law school, so what I used to do was pick few lines from, say, 4 research papers, then paraphrase them, and then put them in another Word document. But, sir, after this session, I've realized that my paper has to be claim-based.
Yes.
So, yeah. So, sir, but what I consider is that claim basis is only limited to the analysis part of our paper. So, for example, we have introduction part, and then we have case laws. That remains, that remains. What we write is that remains.
I understand.
Yeah.
So let me say. Basically, want to say that whatever claim you're discussing comes in the analysis as part of it. But what to do about the previous introduction and conclusion and everything, right? You can't have a claim in that. See, firstly, what you are discussing is a part of the writing style that is adopted by research papers, right? That is adopted in research papers. If you're writing online blogs, if you're writing for blogs and journals, you do not have a particular demarcation with respect to introduction or a conclusion, because usually the limit is very less. It's 1,000, 1,500, 2,000 words, and you do not have specified introductions and conclusions and everything. However, when you're writing a research paper, what you can do is as you rightly said, the claim part comes in the analysis. However, writing the introduction or the conclusion from lifting from different papers and copying from different papers and just paraphrasing it, what it does is, any editor who is smart understands this. It is pretty evident if you have copied your stuff, because whenever you have a novel claim to make it an analysis, whatever claim that you're going to make, that particular claim requires a certain amount of backing in your introduction. And that backing is not argumentative backing, but that backing is foundational backing. As for example, you want to make a claim that, say, the section which demands the serving of notice, mandatory notice to courts and to people in cases of Special Marriages Act, in cases of intercaste marriages, is unconstitutional. When you want to say this, the introduction can deal with a lot of issues. Okay, you can basically say that how what is Special Marriage Act and what is intercaste marriage, and you can deal with all of these stuff into the introduction. But when you are having a claim, that is the very fortunate situation when you are writing a research paper and you have a claim. When you have a claim, you know the limits of your claim. What your limits of the claim are, you're going to say that a particular section which demands for notice is unconstitutional. When you're writing introduction, if you choose to copy from different sources, you're going to introduce your paper in a manner which will be detected by how other people have introduced their paper. That is not going to give a personalized touch. To give a personalized touch, what you need to do is look into what you're going to argue, what claims you have, and list down certain things that deal with that particular claim. For instance, in this example, if you list down your claims, what you're going to have is few things that you need to write about is how how special, you're going to say that intercaste marriages under Special Marriages Act, a particular section related to it is unconstitutional. What you can write into introduction is, how was intercaste marriage governed in India before the Special Marriages Act came? Instead of simply writing what Special Marriages Act deals with, why was it brought? Why is it still there? What laws were previously existing compared to the current situation? How have different jurisdictions dealt with it? In a sense, what you're going to do is provide a holistic understanding of your issue. And if your issue does not deal with the Special Marriage Act, or it does not deal with the aspect of Special Marriage Act, there is no requirement of you copying this stuff from different papers. What you can do is you can dive deep into your paper, into your issue. For example, if you're dealing with a particular section of of the Constitution, what you can do in your introduction and your basic parts, you can dive to Constituent Assembly debates of that particular section, or even debates or versions of that section in the previous acts, constitutional acts before independence, the Indian Constitution Act, how it was existing there. You can have a comparative analysis of it. Anything which personalizes your claim should form a part of your introduction. People work under the assumption that, okay, introduction is the lazy part, the main thing lies in the analysis, so whatever I have to write, I'll write in the analysis. That is a flawed argument, that is a flawed approach towards work, because whatever introduction is, that is going to set the tone for your paper. If your introduction is not personalized enough to your claim, it exhibits a stark mismatch, and the reader loses track, the editors lose track, and the chances of it getting published is starkly diminished when the introduction is not personalized enough. So instead of trying to copy different claims, if try copying your introduction and your conclusion and everything, try to make it personalized. Give a short synopsis of how you're going to argue, what you're going to argue. And to do this, the best exercise that you can do is, you can read papers of good journals. Read 10 to 12 papers of good journals, and by virtue of that, you're going to eventually understand that how different types of journals, different types of authors in reputed journals have approached the introduction. Unless you read it, you're not going to write anything novel. You must have a basic understanding of how people have approached it, and then you will be able to personalize your claims. The ultimate aim is to personalize your claims. So instead of copying, try reading it and then making it more personalized to your central argument. Okay.
Thank you so much, sir. With this, I believe we have reached the end of this particular session. Before we bid goodbye, I would just like to introduce Memo Pandits as an institution. We are India's first floating school for law students, founded in 2014 by Anant Gupta and Rachnendra Bharti. We provide a unique platform that creates content and courses to bridge the learning gap between a classroom and a courtroom. In pursuit of this endeavor, we provide a range of courses uh, for which screen has been shared. Uh, our first flagship course is on research paper writing. As Sir already mentioned and elaborately explained about how one can write a particular research paper and how one should actually approach a particular topic um, depending upon the topic and depending upon the publication that we are targeting. This particular course is, I personally feel, the course for all of you here today, because this course not only makes the entire process of research paper writing fun for you, but would also review a paper that you have written previously and would suggest you as to how you can improve it for a better publication. And our second course is on citation methods. This particular course is something that, regardless of the stage of the profession that you're in, whether you're a law student, whether you're a law aspirant, or you're an advocate, you must do, because citations are an integral part of any research paper, any kind of piece that one may write in their career. And since Sir also mentioned that different publications require different style of citations, and one must know at least the major ones like Blue Book and Oscola in order to master their method of citing a particular thing. So I think this particular course is very, very reasonable and useful. And further, after attending, just by attending this particular webinar, you are entitled to an extra 200 rupees discount by applying this WEB 200 coupon code. So with that, I think the session for today has ended. I would once again like to thank Ayush sir for taking out some time for today's webinar. It was an extremely useful and insightful webinar, sir. All of us, I think, enjoyed it and learned a lot from your experience. Thank you, sir.
Best of luck.
Thank you so much, sir.